それではこれより民事のパートに入ります。ASEAN 各国の裁判官が模擬裁判形式で著作権に関する事例についてディスカッションを行います。それではまず登壇者の皆様をご紹介させていただきます。カンボジアからプノンペン第一審裁判所裁判官のケイ・マネラ氏です。インドネシアから最高裁判所裁判官のウングル・プラウド・サトリオ氏です。ラオスからビエンチャン首都裁判所裁判官のアクソンシン・ウィーサイヤライ氏です。マレーシアからクアラルンプール高等裁判所裁判官のリム・チョンフォン氏です。ミャンマーから連邦最高裁裁判官のソークン・ピュ氏です。フィリピンから地方裁判所裁判官のアーサー・マラバギオ氏です。シンガポールから控訴裁判所のデピュティ・ディビジョナル・レジストラ兼最高裁判所のアシスタント・レジストラで、また地方裁判所裁判官でもいらっしゃいますジャスティン・ヨー氏です。タイから知財や国際取引を専門に扱う控訴裁判所の副所長チャリオス・オラノンシリ氏です。ベトナムからランソン省人民裁判所裁判官のチューリー・フォン氏です。続いて日本側の参加者をご紹介いたします。まず各国裁判官の回答に対しコメントをしていただく方として、東京地方裁判所の知的財産権専門部である民事第47部から田中浩一判事にご登壇いただいています。続いて原告被告の代理人役の先生方です。原告が権利者、被告が被疑侵害者となっています。原告代理人役はアンダーソン・毛利友常法律事務所岩井久美子弁護士です。被告代理人役はベーカー&マッケンジー法律事務所菅彩子弁護士です。そしてモデレーターを務めていただきますのは中村合同特許法律事務所相良由里子弁護士、同じく青山総合法律事務所の宇治裕太弁護士です。それではモデレーターのお二方、どうぞよろしくお願いいたします。
はい、それでは早速始めていきたいと思います。模擬裁判というふうに銘打たれておりますけれども、さすがにこれだけの数の模擬裁判はできないので、実際はですね日本のパートを、ちょっと模擬裁判風に仕立ててみましたということで、各国の、見解については、どちらかというと、パネルディスカッションに近い形で行わせていただきますことをあらかじめご了承ください。それでは早速ですね、本日の事例をご紹介したいと思います。皆様お手元、日本語版は35ページ、英語版は38ページに記載されていますので、そちらをご覧になりながら聞いていってください。ケースの1はですね、日本の A テレビ局で制作された人気アニメなっちゅんと仲間たちの中に出てくる猫のキャラクターラブが、猫ブームに乗って世界的な人気キャラクターになったということを想定しています。著作権者である A テレビ局からあなたの国のテレビ局ポニーテレビが許諾を受けて、あなたの国でもなっちゅんと仲間たちのアニメの配信が行われています。あなたの国のネットショップドンキーネットで猫のキャラクターのラブの形状を模したぬいぐるみ、ただしラブと名付けられてはいませんが販売されているのですが、著作権者である A テレビ局からも、ポニーテレビからも許諾を受けたものではありませんでした。 あなたの国で猫のキャラクターのラブを含むアニメ、ナッチュンと仲間たちの配信および商品化権にかかる著作権利用について許諾を受けた、使用権者はポニーテレビのみでありましたというような想定で、ケース1はなっております。で、各質問がですね、そうか、ケース1に関しては5つ質問がございます。36ページ見ながら、これらが争点になりますということで、5つの質問があります。質問1は、日本のアニメに登場する猫のキャラクターラブの2次元映像は著作権法で保護されますかという質問です。で、質問の2は、ラブを立体化したぬいぐるみが販売されているという場合に、そのぬいぐるみを販売する行為が著作権侵害になりますかという質問です。で、質問3は、図2、3、4、こちら35ページに見ていただきますと、図2、3、4書いてありますけれども、こういったような形態であったら、これは図1に類似して、著作権侵害になるでしょうかと、類似性はどのように判断しますかという質問です。で、質問の4は、ネットショップドンキーネットによる侵害品の販売行為はどのような場合に著作権侵害になるでしょうかという質問です。具体的にはサーバーが国内にある必要はありますかというようなことを、質問します。で、質問の5は、テレビ局 A のライセンシーであるポニーテレビが著作権侵害訴訟を提訴するための当事者適格というのは認められますかと。独占的ライセンシーであった場合、非独占的ライセンシーの場合、あるいは、商品化権についての権利を有していないライセンシーの場合と3つの場合に分けて伺っていきます。それではこれらの争点について、まず日本においてはどのような主張が行われることになるのか、原告被告それぞれの代理人の立場からプレゼンテーションをしていただきたいと思います。ここが模擬裁判風パートになります。それではまず原告代理人の岩井先生、お願いします。
Okay, then regarding question 1, whether or not love, the character of TV animation program should be protected under the copyright law, the answer is, of course, yes. First of all, our work is protected when we can see thoughts or sentiments expressed in a creative way. The personality of love has been expressed in a certain role with certain looks and figure consistently, so we can see thoughts or sentiments are expressed in a creative way in himself. Therefore, love should be protected independent of the original work. Even if that primary claim was not accepted, love should be protected as a part of the original work, not to influence. Regarding question 2, love in three-dimension shapes is also protected from infringement of reproduction right, because the product is the copy of the figure of two-dimensional images of original copyrighted love, which only converted into 3 dimensions. Aside from that primary claim, we also ingest it an infringement of adaptation right, because the stuffed toy is a derivative work of the original copyrighted love. In regard to question 3, the benchmark of similarity judgment should be whether or not we can directly perceive the essential characteristics of the expression. In this case, the essential characteristics of the expression of love are the shape and balance of his eyes, nose, and mouth. For figure 2, 3D shape of love, we are able to perceive those essential characteristics from his eyes, nose, and mouth. For figure 3, also, those looking at it are able to perceive those essential characteristics notwithstanding it is converted into the different gender with a ribbon on her ear. For figure 4, we can still be able to perceive those essential characteristics, notwithstanding it is converted into the different animal, panda. Regarding question 4, the computer server, it is not essential. The server of DonkeyNet is located inside Japan. Therefore, the act by defendant established copyright infringement. Regarding question 5, the standing to sue. PTV, as an exclusive licensee, is eligible to file a lawsuit only by herself. And even if that primary claim was not accepted, as an exclusive licensee, PTV is eligible to file a lawsuit on behalf of copyright owner, licensor, considering PTV's business interest has been infringed by sales of counterfeit. And the same will apply even when PTV is granted non-exclusive license or only the right for distribution, because PTV's business interest is infringed as well in some extent.
I am Ayako Suga. I represent the defendant DonkeyNet. Plaintiff's argument based on copyright infringement should be denied. My arguments are as follows. First, on the substantive law issues. On question 1, the defendant argues that the character itself is merely an idea and is not protected by copyright law unless it is a specific expression. What could be protected in the present case is a specific two-dimensional image in the animation Nacho and Friends. This leads to the defendant's argument on question 2. The character love has never been expressed in three-dimensional shapes. The stuffed figurine sold by the defendant is a cat in three-dimensional shape, which is a different work from the character love. Therefore, on question 3, the defendant argues that all figures 2, 3, and 4 are different work from the character love. For figure 2, the character love has never been expressed in three-dimensional shapes, while the defendant's stuffed figurine is a three-dimensional shaped figurine. Dimension is one of the essential characteristics of an expression. For figure 3, the character love is a male cat, while the defendant's stuffed figurine is a female cat with a ribbon. Gender of the subject is one of the essential characteristics of an expression. For figure 4, the character love is a cat, while the defendant's stuffed figurine is a panda. Obviously, they are different animals. In all these cases, it is not possible to directly perceive the essential characteristics of the character love in the defendant's product. Moving on to the procedural issues. On question 4, the defendant's sale do not constitute copyright infringement under Japanese law because the defendant's servers are not located in Japan. Further, if the court takes the position that the location of the server is not relevant, the defendant further argues that the defendant does not target Japanese consumers in selling the stuffed figurines. The website is not in Japanese and the defendant does not ship to Japan. On question 5, the plaintiff is not the copyright holder of character love, so does not have standing to sue. Japanese copyright law provides that copyright owners may sue for injunctions and damages, but there is no express provision for mere licensees. Regardless of the exclusivity or the scope of the license granted, the plaintiff is a mere licensee and does not have standing to sue for injunctions or damages. For these reasons, the defendant asked the court to deny the plaintiff's claim. Thank you.
はい、ありがとうございました。すみません、皆さん日本の代理人が突然流暢な英語で話し始めたので驚かれたかと思いますけれども、ここからはですね、基本的に英語で進めてまいりたいと思います。それでは、ここから私も突然英語で始めたいと思います。Here are the arguments of each party in Japan. So I'd like to ask each judge how you will decide these arguments in this case in your country based on the answers you had received, we have received in advance. So regarding the first question, whether the 2D image of the character love is protected under copyright. Actually, all the judges answered yes for this question. So, and I'd like to ask Judge K. Manara from Cambodia. I understood that Cambodia is not a member of the Berne Convention. So is the registration required to be protected by copyright in Cambodia?
Hello. Thank you for the question. As you know, that Cambodia is not a Berne member convention. So according to your question, it does not require for the registration to be protected.
登録は必要、カンボジアはベルヌのメンバーではないけれども、登録は必要ではありませんということです。次に、マレーシア、Malaysia is a member country of the Berne Convention. But I understand that you refer to Statutory Declaration or notification at IPO in your answer. So Judge Lim from Malaysia, could you please briefly explain about the Statutory Declaration or notification at IPO? Are these mandatory for the enforcement?
Yes, thank you. Now, Malaysia and Japan, we are both members of the Berne Convention. So what is copyrightable in Japan will automatically be also deemed copyright in Malaysia. And this is pursuant to Regulation 3A of the Copyright Application to Other Countries Regulations, 1990 of Malaysia. So what I think has to be established, if there is a case in Malaysia, is that the proof of the artistic work is copyright in Japan, then the courts will automatically recognize that as copyright in Malaysia. Thank you.
保護のためにデクラレーションやノーティフィケーションというようなものが必要になるわけではなくて、そういうのがありますよという証明のために出すものですということのようです。And some judges also refer to the types of the copyright works. Philippines, Singapore, Thailand understood that the image will be protected as works of drawing and painting. And I would like to ask Justice Olanosili from Thailand. How will the copyrightability of this kind of character in your country?
Thank you very much. As I written in my answer that in my copyright law, there are not provision about the then not express provision about the character. So it doesn't mean that we will protect about the character or not. But after the judgment of the Supreme Court case number 9960 in 2559 BE, it said that according to the lower court fact, the 2D dimension of work will be protected. So it means that at present we accept that a character will be protected under the copyright law in Thailand. Yes.
Thank you. 今裁判官が言及してくださった最高裁の事例、先例というのはウルトラマンの事案だそうです。今のお答えは明文上そのキャラクターの著作物性について、 法律で規定はされていないけれども、そのウルトラマンの裁判例においてウルトラマンのキャラクターが、当然著作物であるということで保護されていたことから、タイでも、ラブのキャラクターは著作物として保護されると判断いたしましたということのようです。And I'd like to ask Judge Phong from Vietnam. Your answer is the image will be protected as works of cinematography. So does it mean that the image from the cinematography should be protected as works of cinematography, even if the image is just a static image, not a moving image?
Yes. My answer for this question is yes. Under Article 12, Clause 1 of Decree number 22, it provides us cinematographic works and work created by the same methods specifies at point E, Clause 1, Article 14 of the Intellectual Property Laws are work expressed in combined animation or not combined with sounds and other means according to the principle of film language. Still images taken from a cinematographic work are part of that cinematographic work. So 2D image of the character love is protected under copyright laws in Vietnam.
映像映画の著作物との一部として、著作権で保護されますということのようです。それでは、キャラクターの著作物性という論点、So lastly, I'd like to judge Tanaka in Japan to introduce arguments regarding the copyrightability of the character in Japan.
Okay. I'd like to point out first that the character is not a statutory language. However, the principle is copyright law protects concrete expressions, not abstract ideas. And our character itself is an abstract idea, so the copyright law doesn't protect a character itself. Concerning to this issue, I would like to point out the Supreme Court precedent in 1997, the Popeye case, held as follows. Essentially, Popeye is a famous American comic character who gains a superhuman strength upon eating spinach. So with wearing a sailor hat, or some tattoos in his arms, as you know. And in that case, the court rendered that a comic character, Popeye, with the same name, appearance, role, and other features cannot be regarded as a copyrightable work. However, the same precedent also held as follows, that is, in order to be regarded as a reproduction of a copyrightable comic strip, a third party's work is not required to be identical in detail with the original drawing in the specific scene in the comic strip, but it is sufficient if the people can perceive that the work describes the character, the original character, which in the comic strip by seeing its features. So I'd like to take some example for if a drawing on a T-shirt, some pattern on the T-shirt who describes a man who is shooting a web from his hand, from his finger, the people can perceive that that man describes Spider-Man. So I have to say that concerning the fanciful character, that is a character in animation or that has a visual image. So it is difficult to draw a line between abstract idea and concrete expression compared with the fictional character, a character in the novel, because the character in the novel doesn't have a visual image. However, the fanciful character has a visual image. So I think in this question, I think this Popeye precedent is also applicable to our cat Love. So in that sense, I think that Love is copyrightable and hold for the plaintiff. Thank you.
はい、ありがとうございます。この論点については、抽象的なキャラクターの著作物性という論点についてもご紹介いただきましたけれども、このケースについてはラブの二次元の画像が著作物として保護されるということで、原告の主張に理由があるということでした。ではクエスチョンの2番に移ります。
Okay, let's move to question 2. So question 2 is about the 3D stuffed figurine of the cat character, also protected under copyright law. Regarding this question, according to the answers in booklet, every country answered that the making 3D stuffed figurine will constitute infringement of the copyright, regardless of that is called as adaptation right or not. So first, we would like to ask the judge from Cambodia. According to your answer in the booklet, in the first bit, would the conduct of making 3D stuff itself constitute infringement of the copyright of the original work?
I think I would say it's a copyright infringement because you have the original work of 2D, which is produced by the TV station A. So if you imagine you have one thing which is the original one, and you make it into the 3D, so it's just more like of cloning from the original to something else, which is produced by the other parties. So just based on my opinion, I think it is a copyright infringement.
Thank you. And further, would making 3D stuff from 2D images fall under a copy work from the original cat character, Love, not infringement of some adaptation right or other right? You say just copy.
If it is produced by the other party who is not the owner of the original work, it is a copyright infringement.
Okay, so the categorize is copying?
Right.
Yeah, okay. 今お答えいただいたように、これ他の国の裁判官の方々の、回答とも共通するところですが、本文に関しては、三次元化する許諾を得ずに三次元化する行為は著作権侵害になると。で、カンボジアにおいては、その本案件のような、概念というよりは、いわゆるコピーという複製に近いんですかね。という形ののものに分類される形での著作権侵害になるというお答えでした。Next, then, we would like to ask the judge from Laos. According to your answer, according to your answer in the booklet, 3D stuffed figurine would be considered as a product of copyright. And you referred to a certain provision of the law. Does the provision set forth some adaptation rights or some other rights? So could you briefly explain the provision?
Yeah, okay, thank you for questions. The first, I would like to explain the Article 126 that I post in Lao intellectual property law. But I think that this article maybe post the missing one because the article 162 that mean is quite similar. It's quite 62 and 26 to 2 and 26. Yeah. So that mean I based on in 162. Yeah. 162 is divided individuals that violate IP rights, counterfeit, receive force or commit acts of unfair competition that result in damage against third party will be imprisonment or fine. That's I refer to.
You say fine?
Yeah.
So, then, okay. So, making 3D stuff to the image would constitute infringement according to your law, right? ラオスにおいても今ご紹介いただいた通りの、規定があるということなんですが、こちらも、この本文に関しては、各国において今、2カ国にお答えいただきましたけれども、結論としては皆様、同じ形で、権利侵害、著作権侵害になるということのようです。そしてですね、本文について、So then, Judge Tanaka, could you tell us your thoughts on this question from the Japanese law?
Sure. My answer is yes. In this case, love, which is a two-dimensional figure, is changed into a stuffed toy, which is a three-dimensional figure. Even though I think that transformation rights that are categorized by the adaptation right, which is stipulated in the Article 27, the Japanese copyright law, cover the three-dimensional figure of love and constitutes infringement. So I hold for the plaintiff concerning this question.
ありがとうございます。ご案内の通り、日本においてはいわゆる本案件、27条の本案件の話だと思うんですね。で、先ほどもちょっとカンボジアのところでも触れました通り、そもそもその本案件というような概念なのか、複製権なのか、日本でいうと江差追分事件のような、ああいう形での、分類というのができるのか否かというのは別にして、いずれにせよ著作権侵害というものを構成するでしょうというところが、各国一致しているところが、本文の特徴かと思います。はい。
Okay, then let's move to question number 3. Please see the figures 2, 3, and 4. Figure 2 is a stuffed figurine in 3D shape. And figure 3 is love with ribbon. And figure 4 is love panda version. And I'd like to confirm each judge's answer, which is similar or not. でここでちょっと新しい試みなんですけど、丸×のカードを用意いたしまして、これで各裁判官に、似てる似てないっていうのを表示していただくことにしたいと思います。ちなみにですね、この丸×形式、日本では一般的ですけれども、海外ではこれが丸がイエスで×がノーと必ずしも決まっているわけではなくてですね、当初挙句三角まで用意しようと思ってたんですけど、日本では三角が丸と×の間なんだっていうことを皆様ほーって言って初めて聞いたかのようにおっしゃっていたので、三角はやめました。でイエスはノーというカードを用意すべきだったんですけど、日本式で頑張りますとおっしゃってくださったので、丸がイエス、×がノーということでご回答いただくということで、ご協力いただいていることをご紹介いたしたいと思います。Okay, so is figure 2 similar and constitute copyright infringement in your country? Yes or no? Please show the cards. Okay, great. In every country, yes. So how about figure 3, the love with ribbon? Yes or no? Similar or not? Okay, every country says yes. And how about figure 4? Panda version, panda love. Then yes or no? Oh my God. Oh, it seems that someone changed the answer, but okay. Philippine, are you sure it's this is yes? This is
my answer is different in the one that you sent us. But we have this jurisprudence that the essence of the copyright infringement is the substantial similarity. So if we apply that to this figure 4, there is a substantial similarity regarding the eyes and the nose of the figure in figure 1.
So you changed your mind, and then figure 4 substantial parts are similar. You judged
as far as the eyes and the nose.
目や鼻や口そのあたりが、サブスタンシャルパート、実質的な部分、本質的な部分が似ているかどうかということで、皆様お手持ちの、回答のブックレットの中では、確かクエスチョン4似てないと、おっしゃってたんですけれども、ちょっと、意見を変えられたということであります。それから、how about Laos, Judge? You originally said that the figure 4 is similar, right?
Yeah.
And you still keep your answer, or you change your mind?
Yeah. Because figure 4 is not it's not similar. Yeah. Then there's figure 2, 3, and 4. In my answer that 2, 3, and 4 has same shape and upside, eyes, nose, and sit in the same model. Moreover, their hands and legs that look very similar to each other. So when I looked 1, 2, 3, and 4 is quite different.
なるほど。Thank you. 目や鼻やの、並び方や、座り方が似ているということで、2と3は似ているけれども、4は違うかなと、ここに来て、ちょっとまた気持ちが変わられたということのようです。いずれにしても一国でも、図4が似てるとおっしゃってくださってよかったです。で、then the other countries, I like to confirm the how to decide the similarity, and so many countries says the figure 4 is not similar, but Judge Kemanera from Cambodia, it seems that size and color seems to be important factors for your similarity judgment, according to your answer.
Yes, that's right.
In the booklet. But the shape of the eyes, as the judge from Philippines referred, the shape of the eyes, nose, and mouth are kind of substantial parts or characteristic feature of love. And then they are actually reproduced in figure 4, even though it is panda, but still the face is exactly the same. And so how do you think about that? If figure 4 is not similar to figure 1?
Well, actually, according to our law, we don't have any specific article that specify like which factor that we can define as a similarity. But this is just based on my own opinion that I can tell that figure 4 is pretty much different from the other 3. At the first impression, if we look at the figure 4, we can tell it's probably a panda. Other than that, it's pretty much just the cat. And as you mentioned about the size of the eyes, the ears, well, yeah, you can think of that as a similarity, but overall, I think it's very different comparing to the figure 1, figure 2, and figure 3.
Yeah. Thank you. カンボジアには類似性についての、判断基準というのが法律で定まっているわけではありませんということで、ズヨンはパンダだよねということで似てないとご判断されたようですけれども、特にその、目や鼻や口の造形というのが似てるか似てないかというところは大事ですねということはおっしゃっています。で、on the other hand, I'd like to ask Judge Phong from Vietnam. It seems that Vietnam has a law. The law says how to judge similarity. So you mentioned your IP law, Article 65. So could you introduce the article in Vietnam regarding the standard for similarity?
Yeah, thank you. In Vietnamese intellectual property laws, we have Article 65, but it's not for copyrights. There is no definition of similarity for copyrights, but just for, I think it's a patent. And there also is no formulaic rule to determine whether there is a similarity in copyrights, in terms of copyrights. Anyway, from our point of view, it's two figures that should be deemed to be a similarity from each other. If they are only different in features of appearance, which are not easily noticeable and memorable, and which cannot be used to distinguish figure in overall. So to look at this for figures of the character love, we may take into consideration aspect or also combination of those aspects like shape, posture, colors, species, and also maybe other mention also the balance of nose, mouth, eyes, ear, things like that, to determine which figure seem to be similar to each other, to the original one. Thank you.
Thank you. ベトナムの知的財産権法の65条は著作物の類似性について言及している条文というわけではないということのようです。で、さまざまなファクターを対比して、回答の中にあるように、すぐ気づかないような部分や特徴的な部分がちょっとごめんなさい、似ていないのであればすぐに気づかないような部分が、似ているというかごめんなさい、ちょっと混乱してしまいました。ベトナムの回答にある通り、の要素で判断しましたということで、ご回答いただきました。すいません。それから I'd like to ask Judge Sokon-Pugh from Myanmar, because the similarity is your answer says that similarity is decided whether it looks confused in the eyes of customers for whom the products are ordinarily or primarily intended to, or whether infringed products are merchandised to the market with intention to deceive the customers. So this standard looks like the standard for the trademark similarity or similarity under unfair competition law. So could you please explain a little bit more about this standard in Myanmar?
Thank you for your question. Actually, there is no statutory provisions or definition regarding this similarity issue, and Myanmar copyright law is the new law. Because of the being the very new law, enacted very recently, so it is clear that there is no case or no precedent regarding this similarity issue, how to decide it. So that's why my answer to this mock trial question, I refer to the decision decided by our Supreme Court. This is a trademark case. Yeah, but it doesn't mean that this unique question is, this is a unique question to all the copyright infringement cases regarding the similarity issue. But infringement cases like applied art or such as character figuring, way of thinking or way of determination on similarity issue might be quite similar to that of the trademark cases. But like a case of pure art, it's quite different. So in this sort of case of pure art, way of judging on the similarity issue will obviously be different. So my opinion is the determination on similarity issue will certainly depend on the nature and merit of the cases.
Thank you. ご案内の通り、ミャンマーちょうど新しい法律が施行されたということで、現段階では著作物の類似性に関する判例というのは一切ありませんと、そういうことでこの回答の中ではですね、商標の類似性なんかを論じている、最高裁の事例などを参考にして書きましたということです。ですけれども、著作権に関して、特に純粋美術の類似性などを判断する場合には、個人的な見解としては、おそらく違う判断基準が示されるのではないかということですので、これは今現存する裁判例に従えばちょっとこういうことが言えるけれども、この先著作権の事例が出てきた場合には違う判断基準が示されるかもしれませんということです。Lastly, in Indonesia, Singapore, and Thailand, similarity will be decided basically whether the substantial parts are similar or not. So I'd like to ask Justice Oranotsiri from Thailand in this particular case, which parts you decide that the substantial parts of the character love in Figure 1?
For my answer in this booklet, I put the face and the rising tail of the Figure 1 as the substantial part of the cat named Love. So that's why I said that the second figure and the third figure is similar to the Figure 1. But for the fourth one, I thought that it's only the eyes and the nose are similar, but the ears and the rising tail is different. So I think that it's not the substantial part enough to become the same one.
Thank you. 目や鼻や口のみならず耳や尻尾もサブスタンシャルパートであると。で、フィギュア4はそれが似てないですよねというお話です。では、lastly, how you in Japan, how you could you will decide for this case.
Okay. I also think that Figure 2 and 3, stuffed toy and the female version of Love, constitute copyright infringement, while Figure 4, the panda version of Love, doesn't constitute copyright infringement. I'd like to explain about that. The Supreme Court precedent in 2001 held as follows. That is, the adaptation right means the creation of another work in which those who directly can perceive the essential characteristics of the expression of the original work. This ruling is considered also applicable to lab drawing and animation. So concerning this criterion, not only the plaintiff, but also the defendant makes generally the same arguments. And I think that those who see love in figure 2, the stuffed toy, and the figure 3, female version of love, can directly perceive the essential characteristics of the expression of the original love. So, on the other hand, as a result of dramatic change from cat to panda, the original love are no longer directly perceivable in the panda version of love because the ears are turned circle and how to be seated. The way to sit down is changed, or colors are changed, totally changed. So that changes undermine the creativity, I think. So love in figure 4 goes beyond adaptation and becomes a new work. So I hold for the plaintiff concerning figure 2 and 3, and for the defendant concerning figure 4. This is my comment.
はい、図2と図3は、原告の言う通りと、図4は、比類似であると。Don't you think figure 3 is just reproduction, not adaptation? Is this too close to the original one?
Okay, this is a somewhat difficult question to answer. However, the female version love, it can be said that it falls under the reproduction right because a change is so slightly, so it can be a copy. However, just as a safety construction, I say that this falls under the adaptation right. Thank you.
これ複製じゃないですかってちょっと聞いてみたんですけど、この問題の都合上、本案ということにさせていただきました。じゃあクエスチョン4に行きたいと思います。
はい、クエスチョン4、これは日本でも、最近話題になっていた漫画村のケースでも話題になっていたサーバーの場所に関する質問ですね。So let's move to question 4. This is about the computer server's location. Is it necessary for the computer server in question to be located in your country in order to apply a copyright law in your country? And is it necessary for the selling methods to be directed and addresses towards consumers of your country? With respect to this question, every country other than Cambodia answered it is not necessary or it is irrelevant for application of the copyright. So then I would like to ask the judge from Cambodia, is there any provisions under the laws which stipulate that the computer server is necessary for application?
Actually, we don't have any specific record or law that stated about the computer server. If we're talking about the computer server, which you mean about the IP where it's located, right? Mm-hmm. So we don't have anything that says about that. So for this question, it's either yes or no for me.
Yeah, okay. 特段その法律があるわけでもなく、またケース、裁判例等があるわけでもないということで、なかなかイエス or ノーで答えるのが難しい質問ですということです。By the way, so in the future, do you think that in some case where the computer server is located outside your country, the infringement of copyright would be possibly found? Do you think, or this question is because it is very, very easy to locate the computer server outside the country, so it's problematic for the protection of the copyright. So in your opinion, okay, so personal opinion, okay, so do you think in the future?
Well, I think in the long term, probably we try to improve day by day and we get better, and yeah, could be possible.
若干ちょっと誘導っぽい質問になってしまいましたが問題意識としてはやはりそのコンピューターサーバーというのはなかなかこう簡単に、場所は、他の国に置けるでも、アクセス自体はその国からできてしまう状態を作り上げることができるということで、カンボジアの裁判官は難しいとはおっしゃっていましたが、インジェネラルというか全体的には、そのロケーション等は関係ないという裁判官の方が多い印象です。So then, next, I would like to ask a judge from Singapore. So, to constitute infringement of copyright, is it necessary for the website to be directed to the consumers in your country?
Okay, I think under Singapore law, there is currently no reported case that deals specifically with this question.
Yep.
But the Singapore courts have had the opportunity to consider a similar question in the context of patent law, of trademark, and of passing off. So in those contexts, the same principles were applied. And there's good reason to believe that, therefore, the same principles will also apply in the context of copyright infringement. So what is this approach that the Singapore courts have taken? At its broadest, the court will take a factors-based approach in assessing whether or not a website sells infringing products to consumers in Singapore. And what is key is the purpose of the website and the intended customers of the website. Some of the possible factors that may be considered would include, for example, whether Singapore is listed as one of the countries in which the infringing products are sold. Another factor could be whether there's the availability of shipping or delivery of the product to a Singapore address, whether there is an option for payment in Singapore currency, whether the website has specific advertisements that are targeted to consumers in Singapore, whether the website generates a large proportion of hits on the internet from Singapore users. And I think earlier on, the Defendant's Counsel mentioned language. And she mentioned that because the website is not in the Japanese language, therefore it is not targeted at Japan. I think in Singapore, we have a slight difficulty with the issue of language because we have more than one language. And we have, in fact, 4 official languages: English, Chinese, Malay, and Tamil. And these languages apply in many other big countries all around the world. So just looking at language in itself is not likely to determine the question one way or another. But it is still relevant to the extent that, for example, if the website is in a language that only a minority, a very small minority of Singaporeans might understand, then perhaps it is a factor against the possibility that it is targeted at consumers in Singapore.
Thank you very much. So, 今のご回答で非常に興味深いのですが、著作権の裁判例がこの本文、この論点に関して直接あるわけではないけれども、特許ないしその商標の、ケースが似たようなものがあって、その原則が適用されるでしょうと。でそこでは、そのシッピングですね、その配送先であったりとか、通貨がその、シンガポールの通貨なのかどうなのかとか、そういう要素もろもろ考慮されて、最終的に、消費者、シンガポールの消費者に向けられたものなのか否かというのを判断することになるでしょうと。でまたこのシンガポールの特徴もおっしゃっていただきましたが、公用語、4つありますと、マレー語などで、その中に英語が含まれていると。で日本のとはちょっと違うのは、そもそも英語が公用語に含まれていて、一般的にその、グローバルなウェブサイトで英語が使われているということはよくあることですが、その言語の要素は、日本とはちょっと違う捉え方をするでしょうということは非常に面白い、回答だったなと思います。Thank you. Then next, I would like to ask the judge from Myanmar. So we understand that the new law is not enforced yet, and there is not precedence. So, but what do you think about whether it is necessary for the computer server to be located in your country?
My answer to this question is no, because this means the location of the computer server is not necessary to locate in Myanmar in order to amount the copyright infringement. In fact, the location of computer server is neither question of law nor question of fact. According to our copyright law, because law doesn't say anything about the location of the computer server. So in this hypothetical case, I think we need to clarify and judge only on whether the Pony TV is qualified to be the right holder under Myanmar copyright law. Then the second is the Dengue not infringe Pony TV's copyright, although that's it. We don't need to think about the locations of the computer server.
Okay, thank you. ミャンマーの方もちろん新法はまだ施行されてないですが、コンピューターサーバーの、ロケーションというのは、この論点に関しては、考慮されるような要素ではないというお答えをいただきました。それでは日本のSo then Judge Tanaka, could you make a comment?
Sure. I think that the acts of donkeynet are considered copyright infringement in some cases, even though a server is located outside Japan. In order to be considered infringement, I think that it is required to find that the means of sales are targeted for Japanese consumers. I think that if display is written in Japanese on the website, it can become a good factor of targeting Japanese consumers. Also, if Japanese consumers can apply for the purchasing of a stuffed toy through the website, can get goods through the website, or there is a statement saying that special discount for Japanese consumers 5% or special souvenir for Japanese consumers, those statements can show that they target for the Japanese consumers. So the bottom line is those factors should be taken into consideration and to lead the consequences, lead the result. So in that case, I think sales of donkeynet can be appraised to be conducted in Japan. This is my comment.
ありがとうございました。言語の点というのは、先ほど申し上げたシンガポールと日本とはかなり違う捉え方、重みが違うというところが挙げられると思います。ありがとうございます。でここで、休憩に入らせていただきます。何時までですか？15分ですね。